It happened on a Sunday, the kind of ordinary Sunday nobody remembers until it becomes the day everything changed. A daughter in Charlotte picked up the phone, expecting to hear her mother's voice, and instead heard a stranger from a state office asking questions about a house she'd never known was in danger. Her parents had owned that home for 26 years, paid it off in full, never missed a tax bill, never so much as refinanced. What none of them understood was that the deed, sitting in a filing cabinet upstairs, had a gap in it, one line of legal language nobody had ever filled in. That gap was enough. By the time the family understood what they were dealing with, the state already had a claim against the property, and the house they thought was simply theirs to inherit was tied up in a court process that would take over a year to untangle. By the end of this video, you're going to know exactly how a paid-off home with no mortgage and no debt can still end up out of a family's hands. And the last way it happens is the one almost every homeowner already has sitting in their own paperwork right now without knowing it. My name is Dana Whitfield. I represent taxpayers directly in front of the Internal Revenue Service, and I walk retirees and their families through the federal and state rules that government agencies will not explain to you, unprompted, because it is not their job to explain them, and in most cases, it is not in their financial interest to explain them either. Before we go further, hit subscribe and turn on notifications, because I release these breakdowns regularly, and the rules I'm about to walk you through change more often than most people realize, sometimes every single year. Here is the pattern I see over and over in probate courts and IRS offices alike. It is almost never fraud. It is almost never carelessness in the way people imagine carelessness. It is a missing form, a deed that was never updated, a document that should have been filed decades ago and simply wasn't. There is no notice when this happens. No penalty letter arrives in advance. The money, or in this case, the home, is simply gone by the time anyone realizes there was ever a decision to make. Let's start with the legal principle underneath all of this, because it matters more than people think. In the United States, when a person dies owning real property in their own name, no trust, no joint owner, no beneficiary designation, that property does not transfer automatically to their children or their spouse. It becomes part of what's called the probate estate, and it is governed by your state's intestacy statute. If there's no valid will, or by the probate code generally, even when there is one. Under most state probate codes, modeled loosely on the Uniform Probate Code adopted in some form by roughly 18 states, the court, not the family, determines who inherits, in what proportion, and under what conditions, unless every step of the estate has been properly documented in advance. The property is not yours the moment a parent dies. It is an asset under the jurisdiction of a probate court until that court says otherwise. Every year, state treasuries collectively hold billions of dollars in unclaimed property and estate assets that families never formally claimed either because they didn't know the process, missed a filing window, or assumed inheritance was automatic. It is not automatic. It has never been automatic. The court processes what is filed, nothing more. Trap number 1 is dying intestate, meaning without a valid will, and it is far more common than people assume, even among homeowners who consider themselves organized. Here's the plain mechanism. If a parent dies without a will, state intestacy law decides who inherits. And that formula does not care about your family's actual relationships. It cares about legal categories: spouse, children, parents, siblings, in that order, with fixed percentages that vary significantly by state. In a number of states, a surviving spouse does not automatically inherit 100% of a jointly titled home if the deceased spouse has children from a prior relationship. The estate can be split between the surviving spouse and the children, sometimes forcing a sale of the home just to divide the proceeds. This is codified state by state, but the general framework tracks provisions similar to those found in the Uniform Probate Code, Article 2, Part 1, which governs intestate succession shares. I want to walk you through Marjorie Ellison's situation because it's the clearest version of this I've seen. Marjorie was 68, a retired school administrator from Dayton, Ohio. Her husband died without a will, and the house worth about $210,000 was titled solely in his name from before their marriage. Under Ohio's intestacy statute, because he had two adult children from a first marriage, Marjorie was entitled to the first $60,000 of the estate plus one half of the remainder, with the two children splitting the other half. That meant Marjorie's actual share came out to roughly $105,000, and the house had to be sold to divide it, because none of the three heirs could afford to buy the others out. Marjorie had lived in that home for 11 years. She lost it, not because anyone did anything wrong, but because no will existed to say the house should pass to her outright. The fix here is not complicated, but it has to happen while both parents are alive. A properly executed will, ideally paired with either a revocable living trust or a transfer on death deed, depending on the state. If your parents already have a will drafted, the operative question is whether it was executed with the correct witnessing and notarization requirements for your state, because an improperly witnessed will can be challenged and thrown out in probate court, which puts you right back in intestate succession anyway. There is no statute of limitations that helps you after the fact. Once the death has occurred, the opportunity to avoid intestate succession through simple documentation is closed. The only remaining options are far more expensive, far slower, and far less certain contested probate litigation that can run tens of thousands of dollars in legal fees alone. Trap number 2 is one almost nobody sees coming, and it's called Medicaid estate recovery. Here's the plain English version. If a parent received Medicaid benefits for long-term nursing home care at any point after the age of 55, federal law requires states to attempt to recover those costs from the deceased person's estate after they pass away. And in the majority of states, that includes going after the home. This isn't optional for the state. It's federally mandated under 42 U.S. Code Section 1396P, which requires state Medicaid programs to seek reimbursement from a recipient's estate for the cost of long-term care services unless a surviving spouse, a minor child, or a disabled child is still living in the home. The average nursing home stay covered by Medicaid runs somewhere between 18 months and 3 years. And at national average costs exceeding $9,000 a month, a state's recovery claim against an estate can easily exceed $150,000. I worked adjacent to a case involving Harold Kessler, a retired machinist from Erie, Pennsylvania, whose father spent the final 2 years of his life in a Medicaid-funded nursing facility after a stroke. Nobody in the family knew that Pennsylvania's Department of Human Services had a legal claim against the estate until a letter arrived 4 months after the funeral, informing them that the state intended to file a claim against the house for $118,400, nearly the full value of the property. The family had no idea this exposure existed because nobody explained it to them when their father was admitted to facility. This is where it gets important. There is a legal mechanism to protect the home from estate recovery, but it has to be set up before the Medicaid recipient passes away, and ideally years before they ever need long-term care. Certain irrevocable trusts, properly structured and funded outside the 5-year Medicaid look-back period, defined under 42 U.S. Code, Section 1396 PC, can remove the home from the recoverable estate entirely. Alternatively, some states allow what's called an undue hardship waiver, filed using a state-specific form. In Pennsylvania, for instance, this is handled through the Department of Human Services Estate Recovery Program, hardship application, but hardship waivers are granted narrowly and are far from guaranteed. The urgency here cannot be overstated. The 5-year look-back period means any transfer of the home into a protective trust made less than 5 years before a Medicaid application can trigger a penalty period that delays eligibility entirely. Waiting until a parent is already in declining health to address this is, in most cases, already too late. Trap number 3 involves families who did everything they thought they needed to do. They added an adult child's name directly onto the deed, believing that would avoid probate altogether. It often creates a worse problem than the one it was meant to solve. When a parent adds a child as joint owner with rights of survivorship, that child becomes a legal co-owner of the property immediately, not just upon the parent's death. That triggers a gift for federal tax purposes under Internal Revenue Code Section 2503, and depending on the value of the home, it may require the parent to file IRS Form 79, a gift tax return, even if no tax is ultimately owed because of the lifetime exemption. But the bigger issue is exposure. Once your name is on that deed, your parent's home becomes reachable by your creditors, your divorce proceedings, or a lawsuit against you, none of which your parent can control once the transfer is made. I want to tell you about Patricia Nowak, a retired dental hygienist in Albuquerque, New Mexico, who added her son to the deed of her paid-off home in 2016, thinking it was a simple way to skip probate. Her son went through a divorce in 2021, and under New Mexico's community property framework, his one-half ownership interest in that home, appraised at $85,000, became a marital asset subject to division. Patricia, who was still living in the home at 73 years old, was forced into a legal battle just to keep her own house, ultimately paying her son's ex-spouse a settlement of $22,000 out of her retirement savings to retain full ownership. None of this would have happened with a properly drafted transfer on death deed. Instead, a document, legal in over 30 states, that names a beneficiary to inherit the property automatically at death, while leaving the parent as sole owner and in full control during their lifetime. The form itself is simple, typically just 1 or 2 pages, recorded with the county recorder's office, where the property sits, and revocable at any time. The mistake in Patricia's case wasn't malicious or careless. It was a reasonable-sounding shortcut that skipped the legal step actually designed for this exact purpose. So, here's what I want you to do. The exemptions, the breaks, the refunds, most seniors already qualify for but never claim. I've put them all in one place, state by state, form by form, so you don't waste hours digging through government sites. Everything's laid out fast and simple, so any senior can find exactly what applies to them. No matter what state you're in, there's money you're leaving on the table. It's called the Senior Exemption Playbook. It's in the first pinned comment right below this video. Just tap it once and you'll have everything you need. Now, stay right here because the last trap is the most dangerous one in this entire video, and it's the reason I made this whole video in the first place. Trap number 4 is the one that catches even families who have a will, who avoided Medicaid recovery, and who never added anyone improperly to a deed. Because this trap isn't about what's written down. It's about what's left unfunded. Here's what I mean. A revocable living trust is one of the most effective tools for avoiding probate entirely, and I recommend it constantly. But a trust only controls property that has actually been retitled into its name. If your parents created a trust, paid an attorney several $1,000s to draft it properly, but never went back and executed a new deed transferring the home from their individual names into the trust, that home is not protected by the trust at all. It still passes through probate, exactly as if the trust never existed, because legally, the trust never owned the asset. This is called an unfunded trust, and it is, in my experience representing families through this process, the single most common and most expensive mistake in all of estate planning, more damaging than not having a plan at all, because families believe they're protected when they are completely exposed. I want to walk you through Robert and Elaine Castellano's situation out of Scottsdale, Arizona, because it demonstrates exactly how this unfolds. Robert was a retired aerospace engineer. In 2011, he and Elaine paid an estate attorney $2,800 to create a revocable living trust specifically to keep their $440,000 home out of probate for their three children. The attorney handed them a binder with the trust document and a cover letter instructing them to sign a new deed, transferring the home into the trust's name, and record it with Maricopa County. That letter sat in a drawer. Nobody ever recorded the new deed. Robert passed away in 2019, and Elaine followed in 2023. When the children went to settle the estate, they discovered the home was still titled in Robert and Elaine's individual names, not the trust, meaning it had to go through full probate anyway, at a cost of roughly $31,000 in attorney and court fees, and a process that took 14 months to resolve. The trust itself, the document they paid to create specifically to avoid this outcome, provided zero protection because the underlying transfer was never completed. This is codified simply enough. Under general property law principles applied in every state, a trust can only distribute what it legally owns. And ownership of real property transfers only through a properly executed and recorded deed, not through the existence of a trust document alone. If your parents have ever mentioned setting up a trust, the single most important question you can ask is not, do you have a trust, but was the deed to the house actually transferred into the trust's name? And is that transfer recorded at the county recorder's office? You can verify this yourself, often for free, by searching your county recorder's or register of deeds online property records, using your parents' address or the parcel number. If the current owner of record still shows your parents' individual names rather than the Castellano family trust or similar trust language, the home is unprotected right now. Today, regardless of what any binder in a drawer says, this is fixable in a single afternoon while your parents are alive and competent to sign. It becomes extraordinarily difficult, sometimes impossible, without court intervention, the moment they're no longer able to execute new documents. So here's your action plan, and I want you to actually do this, not just save the video for later. First, pull the current deed to your parents' home from the county recorder's or register of deeds website. Most counties have this searchable online for free, using either the address or the parcel number. Second, confirm exactly how the property is titled: sole ownership, joint tenancy, tenancy in common, or trust ownership, because each one triggers a completely different legal outcome at death. Third, if your parents have a will, locate the original signed and notarized copy, not a photocopy, not a draft saved on a computer, because most probate courts require the original document and confirm the date and witnesses meet your state's execution requirements. Fourth, if either parent has received or is likely to need Medicaid-funded long-term care, contact an elder law attorney now, not after a health crisis, to discuss protective trust planning before the 5-year look-back period becomes relevant. Fifth, if a trust already exists, request written confirmation from the attorney, drafted it, or check the recorder's office yourself, that the home's deed was actually transferred into the trust's name. This takes about 10 minutes to verify and can save your family tens of thousands of dollars. Sixth, gather the supporting documents now while everyone is alive and able to help. Certified copies of birth certificates, the marriage certificate, the original deed, any prior mortgage payoff statements, and a list of account numbers for anything held jointly or individually. If you need to call a state Medicaid office, the IRS, or a county recorder to verify any of this, only use the number listed on your official government correspondence or the agency's verified website, never a number given to you by someone who called you first, no matter how official they sound. Because impersonation scams targeting exactly this kind of estate confusion are extremely common. That daughter in Charlotte, the one who picked up the phone expecting her mother's voice, eventually got her parents' home back. But it took 14 months, a probate attorney, and money that should have stayed in the family instead of going to court costs. The house was never really at risk from a stranger, or from bad luck, or from anything anyone would call a mistake in the moment it happened. It was at risk from one line of legal language nobody had ever filled in. That's the pattern. Every time, the rules aren't hidden, they're just never explained to you until it's too late to use them. Go check that deed today.